And our next speaker will be Margaret McCann, and I think we'll take a break. After.
Oh, after.
No, you.
Okay.
No, after.
Didn't know I had that effect on people.
Good afternoon. Welcome.
Good afternoon. I am Margaret McCann, and I am an attorney for the American Federation of State, County, and Municipal Employees. Before being an attorney with AFSCME, I was an attorney at the Labor Board. And I was also, before becoming an attorney, I was a union organizer and a collective bargaining representative. I want to thank the board for the opportunity to speak about the board procedures, which, speaking on behalf of an organization that is dedicated to workers' rights to organize and collectively bargain, the board's processes are important to us and to all American workers. We commend the board for undertaking this process of revising the rules because process does matter. The board is charged with regulating the process of organizing and collective bargaining and accommodating the competing interests of the parties. The board's election process is actually okay if you were in the 1960s. The board needs to comport with today's technology and come into the 21st century in a 21st century world. The board processes as they exist today have become hijacked by the employers. How has it become that the election process has been subsumed by the employer's right to communicate to its workers? Under the Act, employers can communicate with their workers, and they should be able to, as long as their communication is not threatening. But the Act was enacted so that workers could collectively communicate and bargain with their employers. The premise that has been set forth today, that somehow the proposed rule will stifle employer speech, is just not true. And any statements put forth today or tomorrow to the contrary are just inaccurate. How can filing a representational petition electronically in real time stifle employer speech? It does not. How can sending an Excelsior list within 2 days instead of the current 7 days stifle employer speech? It does not. How can convening a hearing within consecutive days stifle employer speech? It does not. What it does, it injects some certainty into the process so that all parties, the employer, the union, and most of all the workers, know when the hearing will convene. How will having the employer take a position about the petition for bargaining unit stifle employer speech? It does not. In fact, that rule would be asking the employers to speak a little more, to tell the board what they believe the petition for bargaining unit represents. How can delaying 20% or fewer of the workers' eligibility status delay employer speech? It does not. What the proposed rule does is allow the board to control the election process, to eliminate undue delay, and provide certainty to all the parties. The Supreme Court mandated that the board should be promulgating rules that are recorded accurately, efficiently, and speedily. And the board's proposed rule attempts to comply with this mandate. The proposed rule contains common sense changes to the election process. It is injecting fairness, provides certainty, and updates procedures in this technological age. Thank you. And I thank the board for the opportunity of letting us address this important issue.
Thank you. Thank you for being here today. Is there any question? Thank you very much. Why don't we take a break at this point and be back promptly at 2:30?